Thanks very much for the opportunity to read Rick's paper, which I think was a really very rich paper, combining as it does an analytic inquiry into the nature of constituent authority, together with a comparative law exploration of its many instances and permutations. I'm not a comparativist. I'm going to leave the comparative law material to one side. I'm going to concentrate on the substantial analytic contribution about constituent authority. I'll be mostly an extension of Rick's paper. I will have one critique perhaps about the temporal nature of constitutions, and I'll talk a little at the end about what I think of some of its implications for originalism, a completely different kind of implication for originalism. Of course, I'm only going to discuss the one constitution of which I'm knowledgeable. The first contribution of this paper, I think, is to distinguish constituent authority from constituent power. Constituent power, as the name implies, the raw power to establish a regime, maybe a constitutional regime. Constituent authority is that power plus another element, a social sense that the power of creating a constitution is exercised legitimately. In our society, a military takeover, establishing a new constitution, might be an exercise of constituent power, but it would not be an exercise of constituent authority. One might in fact argue that constituent authority is necessary to establish a constitution in any modern sense. A constitution without any legitimacy is a document that people have no inclination to obey, but before the raw power that stands continuously at every moment beyond its exercise. I think Rick is completely right. The constituent authority is the more fertile concept in thinking about constitutionalism. Constitutional is bound up with legitimacy. As important as legitimacy is to constitutionalism, Rick believes, and I completely agree, that constituent authority can never be reduced or can never be identified by its relation to a legal form. As a result, the constitutional order ultimately rests on a decision, not a norm. The decision every day, the Constitution of the United States, for instance, could be replaced by a new constitution should that act be generally perceived as legitimate by the decisions of the people of the United States. So I agree that there's a strong formal, basic dichotomy between formal authority and constituent authority. But I want to explore how a constitution, in particular, a good and successful constitution, might sharply limit the possibility of the exercise of constituent authority. As a result of this analysis, I'll argue that it's not necessarily the case, I think as Rick sometimes implies, that the legitimacy of the Constitution declines with time, releasing greater opportunities for a refreshing act of constituent authority. My essential point is that because the constituent authority exercised outside a Constitution is a substitute for continuing with the legal form, the practical relevance of constituent authority depends on the costs and benefits of each alternative. The better any constitution, both in its legitimacy of creation and crucially in the perception of the results it delivers, the more relatively costly is the resort to constituent authority. In this sense, because you might think, in this sense, that a perfect constitution would be a constitution that crushes constituent authority because no people would ever want to replace it. But even a good constitution, one that falls far short of perfection, sharply limits the exercise of constituent authority, because the exercise of constituent authority is costly. That is particularly true when the people are perceived to be legitimate constituent authority for the Constitution. Because, and I think this is another power of Rick's paper, he notes how the people are to exercise that power is a very difficult question. What makes their voice authentic? A majority referendum, a majority act of the legislature, or some more consensual mechanism? This uncertainty raises substantial costs of exercising constituent authority rather than sticking with the formal authority. Because it's hard to know ex ante, even by the people, what actions are going to be perceived as legitimate. This offers a substantial margin of error, as it were, where a constitution can have many imperfections, and yet constituent authority may not be a live option. This can be illustrated by the consideration of the United States Constitution. Certainly in one way or another, the people are the legitimating authority of our system of governments, and thus in some way retain the constituent authority to make a new constitution or change it outside of its formal rules. Nevertheless, and indeed Mike Rappaport and I have tried to show in some of our own work, that there are a lot of difficulties with changing the Constitution, and that means you may accept a lot of constitutional failures and mistakes and still not go to a new Constitution. The lack of practical scope for constituent authority is underscored because the United States has a process that's widely perceived as legitimate for changing it, the amendment process. Moreover, the United States has had in the public mind so many good results over so many years, the constituent authority of the people is much reduced. It would seem very parlous to junk this Constitution and start over because it would make the property rights and other rights insecure. And this is, in some sense, I have some slight disagreement maybe with Rick, given that the legitimacy of a Constitution's formal authority is measured by the prospect that some constituent authority can be exercised to overturn it. A constitutional's formal authority and legitimacy may increase with time, not become more remote. I mean, the Articles of Confederation were very close in time, and yet it was quite easy, perhaps, to exercise constituent authority to overturn them. I think it's much harder, even though we're very far from the original Constitution. The way one to think of this is perhaps in this way, that constituent authority, we can think of it like a business slogan. It means that you've got to earn the customers every day. That's one way of thinking of constituent authority, right? That they can go away, they can change things, but it's much easier with a product to go and exercise your constituent authority to go for some other kind of product. But precisely because of the collective action issues, particularly when the people are thought to be the legitimate authority, the Constitution is in a good position to win its customers every day, much better than some sort of private enterprise. Thus, it seems a focus on the practical scope for constituent authority in any democracy necessarily requires consideration of how good is the Constitution. The better the Constitution, the less room there is for the exercise of constituent authority outside. The cost of destabilization, including the cost involved in deciding how the people's voice will be exercised, which is certainly just not clear, are powerful incentives to stick with the Constitution you have. One measure, in fact, of the limited constituent authority in the United States is that even some powers formally in the Constitution, and Mike Rappaport, I think, has brought this out in some of his own work, really aren't used. The idea that we certainly could call a new constitutional convention, but even a limited purpose constitution convention, which might be imagined in Article 5, people are very worried about it precisely because there's a fear of a runaway authority who knows that it might trigger some constituent authority. So we don't even want to go down that road. So the final question is how appropriate to consider at this conference is whether this paper has anything to tell us about originalism, and I have a slightly different take on what it tells us. And here I'm talking about originalism in the normative sense, not simply the positive sense, the normative sense in which whether judges should follow the original meaning and other actors 200 years later. And I think the one thing it may suggest is that whatever its other virtues, originalism isn't necessary to reducing much the opportunity for constituent authority, for changing the Constitution. Given the great costs that I've described of replacing a Constitution, there's a lot of slack, maybe not unlimited slack, for non-originalist interpretations, even if, as I believe is the case, those interpretations on average make the Constitution worse. And even if they end, and this I think is a more controversial point, in some sense, even if they erode over time, in some sense, the legitimacy of the Constitution. Here's the analogy I would make. Adam Smith once famously said there was a lot of ruin in a nation. I think he meant by that there are a lot of mistakes a nation can make economically, politically, and still be a viable ongoing entity, not subject to change or dissolution. There are many costs to revolution and to exit. The cost of the exercise of constituent authority by the people means that we can echo Smith. There's a lot of ruin in a constitution. Both originalists and non-originalists can fight their battles normatively, important as they are, without much risk of triggering that authority's exercise. And that's one of the reasons the battles can be so bitter.